Thank you very much. Thank you for inviting for the possibility to learn a lot and to speak. My legal considerations are published in this book, thanks to Ode Merkovich. So I'd like to concentrate on some general thoughts on legal issues. Five of them. The first one is the genesis of the problem, and I would say that the observation that mater semper certa est remains precise, accurate in most of the states of the legal systems in the world, where maternity is defined as the personal status, it is filiation of the woman who gave birth to the child. And in most legal systems in the world, it is not possible to conclude contract on pregnancy, on birth, on from other side, on acquiring a civil status of filiation. But, so this ban on surrogacy may be deducted from the whole provisions or may be stipulated expressly. Another thing is criminal law. And what is the problem? The problem from the perspective of this group of countries is that in another group, in some states, a kind of, let's say, competitive way of acquiring the legal status of mother and father or homosexual parents A or B has been introduced via this contract with surrogate mother. Usually a woman, as it was said yesterday, coming from poorer societies, and usually with assistance of professional business professional intermediaries and organizers. So from the perspective of the first group of states, of the first group of legal systems, the core problem is how to protect what kind of instrument to protect their legal principles on maternity in particular. The second issue is terminology. Terminology is important, especially in public debate, but also in academician and in legal one. And in my opinion, the terminology shows paradoxes and many, and even may cause misunderstandings. So we should be careful. For example, surrogate mother. Surrogate mother, with this term, is described not the woman with the final legal status of mother of maternity, who finally takes care of child, but this term describes the woman who was pregnant and contractually transferred this status to another person. Then some laws, I would say, have hidden solutions that can be contrary to the common understanding of surrogacy. For example, I have Cambridge Dictionary says, surrogacy explains in a way narrower than in functions in many legal systems. It says that it's an action of a woman having a baby for another woman who is unable to do so herself. So this common meaning, this definition, this may not describe, for example, delivering child to single men or same-sex couples. The role of lawyers, of academic staff, is also to clarify the sense of terminology applied to talk seriously. What's more, it may be also controversial whether as surrogate, in a meaning of subsidiary, can be named the delivery of child to constellations of persons within fertility, conception, reproduction is generally in biology not possible. Maybe the terms of surrogate pregnancy or surrogate birth would be more precise. The third thought is in fact the essence, And to cut the long story short, such development laws in some countries, and especially the practice, the reality of its operation, may be deeply questionable from the perspective of human dignity. It is a child's and woman dignity. Also, the issues of child trafficking may be raised, and finally, it may also cause the erosion of system of adoption. The surrogacy contexts are more, let's say, attractive than the system of adoption. Many problems concern the understanding of the principle of best interest and welfare of child. Everyone talks about best interest and welfare of the child. But in particular, the choice between the meaning individual, let's say, hic et nunc evaluation of a given child and the meaning of general and long-term perspective of the whole of children and the society. So such trends in law, of course, may raise objections and looking for protective actions in in other legal systems in the world. The fourth issue, the fourth thought are so far negative consequences of surrogacy were mentioned in some international documents, but there is no binding tool in fact. Just two examples. The Council of Europe's very detailed report of 2016 postulates the ban on commercial surrogacy and what's also important, limiting the access to cross-border procedures to citizens not residing in a given state. And by the way, it was estimated that 99% of surrogacy contracts are commercial, so non-altruistic. The second example, one could say that it's a private matter. It's not a global common issue, but a private matter of woman and disposal of her body. And according to Article 21st of Council of Europe's Convention of 1996, the human body and its parts shall not, as such, give rise to financial gain. And we could say that this ban, functioning ban, should apply a minori ad maius also to the nasciturus and the born child. And maybe the third example, Hague was mentioned, and Hague Convention. I would like to recall existing convention, Hague Convention on Inter-Country Adoption of 1993. And in this Hague Convention of 1993, Article 4, paragraph 3, says that inter-country adoption, transborder adoption, there is a condition of no payment or compensation of any kind. And this convention is a binding instrument in many countries, members to the Hague Conference of Private International Law. In my opinion, even now, this provision could be applied mutatis mutandis to the surrogacy, to the transborder surrogacy. And the fifth, the last thought is that an international convention like the proposed Casablanca Declaration could bring effective measures to protection of legal order in a given state, but also on international arena. But it should not only consist of the ban of direct or indirect ban on surrogacy in a given state, but in my opinion, it should also contain measures aiming to non-recognizing of foreign law and foreign judgments or foreign birth, even birth records. So it should contain also of a kind of ban of import from a broad ban on effects of procreation tourism that is functioning and developing, as we have heard. Otherwise, the, let's say, only national ban would be only theoretical and simply ineffective. So summarizing, in addition to measures to public law and the discussion of imposition of penal instruments, also substantive law, family law, civil law, and private international law instruments should be emphasized. And the latter includes application of so-called ordre public clause. Order public clause is a general part of private international law and general part of international civil procedure, as well as second general institution that is called mandatory rules of lex forum, of lex fori. And the essence of those legal institutions is the possibility of refusing effects of foreign law or judgment, including birth record, when they are contrary to the fundamental principles of own law of lex fori. And I do not know the details, but as I have heard, I think that this Italian example of detailed and complex, what is important, complex statute on inter-country surrogacy may be an inspiration for the other states and for the detailed provisions of international treaties. These are 5 general thoughts. As far as the details are concerned, if somebody is interested, please have a look at in the text in English at page 43. Thanks a lot for attention.